Victim advocates possess substantial knowledge of and experience with justice systems. The victims that they serve look to advocates to answer questions about those systems and their rights. It is important that victim advocates are able to provide accurate and timely information and services to victims, and to do so without crossing into practicing law. This training video will examine the unlawful practice of law by identifying the key components of what makes something the unauthorized practice of law, describing practices to avoid, and articulating why avoiding the unauthorized practice of law is important for victims and advocates. This training video was supported by an award from the Oregon Department of Justice. Before we can avoid the unlawful or unauthorized practice of law, we need to know what practicing law is. Take a moment by pausing the video to try and articulate what types of activities would be considered practicing law. Some activities may be clear, like representing a person or entity in a court or court-like proceeding, preparing a document on behalf of a specific person for filing in any court, administrative agency, or tribunal, or negotiating legal rights or responsibilities on behalf of a specific person or entity. These activities are things that are generally recognized to be the practice of law. But there are activities that are harder to identify as practicing law, such as preparing or expressing legal opinions, or giving legal advice to or for another person. Having just defined what practicing law entails, we now turn to the unlawful practice of law and see that it can take a few different forms. These include an individual intentionally holding themselves out as an attorney when not licensed to practice law, an attorney practicing law in a jurisdiction without a license from that jurisdiction, or a non-attorney legal staff, such as a paralegal, providing legal advice in the course of employment. What we are really concerned with as victim advocates working with victims is the final type, an individual providing assistance that unintentionally crosses over into legal advice. When we are assisting a victim who has found themselves in this new, potentially scary world of the legal system, they are going to need help. They will have questions, they will need support. The question for us is, when can we provide that assistance, and when does that assistance require legal advice, that is the practice of law? So that leads us to the focus of this training. What is legal advice? There is no concise, detailed answer to what constitutes giving legal advice. Unfortunately, it is a bit amorphous, but there are generally two common components: exercising one's professional judgment and applying legal principles to the facts of an individual's case or circumstances. Let's dig into that a bit deeper. Working as an advocate in connection with the justice system, you have learned and acquired certain information and training to do that job. When you are assisting a victim, you are pulling from this bank of knowledge and skill to educate the victim about their rights, so that they can make the decisions that are best for them under the circumstances. Giving legal information is always okay, but it becomes giving legal advice when you exercise discretion and start tailoring legal information to the facts and circumstances of someone's individual case or scenario. So, when deciding whether you are giving legal advice, ask yourself this: am I taking what I know about the law and applying it to the facts of this client's situation? Since giving legal information and giving legal advice can feel very similar, it is useful to look at the differences. One of the best ways to keep yourself from giving legal advice is to avoid answering "should I" questions in relation to a victim's legal rights and interests. Not only does responding to a "should I" question undermine survivor agency, but it requires the exercise of professional judgment, whereas answering "how do I" questions merely requires giving information. So when asked a question, see which side of the line the question falls. Another tip is to ask yourself, am I giving options from which the victim may choose, or am I giving the victim my opinion regarding such options? Options are a way to provide the victim with agency to decide what they want to do. That is not only okay, but it's a key part of an advocate's role when talking to victims about their situation. It is okay to inform victims of what laws exist and what the law says, but it is not okay to interpret those laws for victims. Interpreting how the law would apply to the victim is an example of giving legal advice. Your refusal to answer the "should I" questions or requests for your opinion may frustrate certain victims. It is best practice to be ready to explain why you cannot answer those types of questions, why you can't give legal advice, and why not answering is about respecting the survivor to answer the why in the most trauma-informed way. And when giving legal information, be aware of how you are likely perceived by victims due to your position as a person with knowledge and expertise. While you may be very careful to only provide legal information to victims, how you do so may be interpreted as legal advice. What does that mean? Let's look at an example. You listen to a victim's story about the crime and their current fear that the person will harm them again. After listening carefully, you tell the victim that Oregon has several types of protection orders that a person can apply for. You provide the victim with all the various options and their descriptions. You never say which one the victim should seek or that they should seek one at all. However, because the victim looks to you as someone who has expertise in serving victims, they will likely assume that you believe that they should get a protection order. Because of your position, your words and actions may be perceived differently than you intend. Before sharing options within a particular course of conduct, know that by narrowing to that course of conduct, for example, seeking an order of protection, that may be perceived by them as legal advice. Protection order forms are only one of the many legal forms that victims may need to fill out to access or assert their rights. Generally, it would be legal advice for an advocate to tell a victim what to fill in, advise victims of the consequences of completing the form in a certain manner, opine about the likely outcome of submitting the form, or advise a person that a particular legal form is appropriate or inappropriate. Advocates can, however, help ensure the victim's words get into a form. If you find yourself asking questions that go beyond what is needed to fill out the form, be careful, since you may be teeing yourself up to exercise professional discretion or apply specific facts to the law, which may be legal advice. Some jurisdictions specifically address non-lawyers helping individuals in filling out forms. For example, Washington State allows advocates to assist victims of stalking in the preparation of petitions for stalking protection orders. The law specifically states that advocates are not engaged in the unauthorized practice of law when providing assistance in this manner. Let's use an example to highlight how you might respond to a victim seeking help with forms. You are a community-based advocate at a legal aid organization serving individuals of limited income. One of the clients you have been working with says they want to get a protective order against the person who harmed them. They ask you which of the protective orders available in your state they should choose. Pause the video and contemplate how you would respond to this request. Two things likely jump out at you. One, this is a should I type question, and that will tip you off that you are likely not going to be able to answer the question as asked. And two, as we just discussed, you cannot tell a victim which form to use for their particular case. But we want to assist the victim, so what can we do? First, you would inform the victim that your legal and ethical obligations prevent you from telling them which form to use, because that would be giving legal advice and you are not a licensed attorney. Rather than telling a victim which form to choose based on the facts of their case, you might instead explain circumstances where each one might apply. For example, one may be used with family or household members, another might be used specifically in the stalking context, and so on. And the victim could then select the appropriate form based on the information you provide about the different forms. Some organizations have written short scenarios that help place the protective orders in context. Others use charts that compare options. There are lots of ways to do it. Let's look at another scenario for practice. You are a system-based advocate working in the prosecutor's office. A victim in a current criminal case calls you and wants to know if they can include the cost for new locks on their doors on the restitution form that your office sent them. They tell you the form doesn't have a space for those kinds of expenses. Pause the video and take a moment to think what considerations come to mind when you read this scenario. This scenario involves the victim's right to restitution and forms. As an advocate working in the prosecutor's office, you have undoubtedly acquired a lot of knowledge about restitution in criminal cases. You may be tempted to quickly answer the question based on what you have seen in other cases, in court, or whatever prosecutors have said. However, be careful only to provide information and not advice. This is an example of a question regarding what information to use to fill in a form. Remember, that falls under legal advice. So what can you say or do to assist the victim? Well, you may want to present the victim's question directly to the prosecutor or have the prosecutor speak to the victim about the locks on the door. You could inform the victim that the office's restitution form does not anticipate every cost that a crime victim may have as a result of a crime. Victims may write down any cost that they had on the form, and then it would be up to the court to decide if it is recoverable under restitution. But remember that the victim may perceive your information as advice, so work to ensure the victim knows you are sharing information only so that they can choose what to do. Another option is to provide a referral to a victim's rights attorney who can look over the victim's costs. It is never legal advice to refer to an attorney. This may be a preferred option if the prosecutor is not willing to seek restitution for certain items that the victim feels should be paid for by the defendant. In a third practice scenario, you are a community-based advocate who works in a domestic violence shelter. You receive a call from a client who tells you that they received a subpoena for their mental and physical health records. They ask you if they have to turn the records over. Which option is the better response? 1. Tell the victim they will be required by the court to turn over all documents if they get a subpoena, so they had better do it if they don't want to get into trouble. 2. Tell the victim that in your state, victims of crime have a right to refuse document requests, and that the law provides privilege protection for medical documents. They should not turn over any documents. 3. Tell the victim that you aren't an attorney and can't provide legal advice, but that you would destroy the subpoena and pretend it didn't exist. Or 4. Tell the victim that you aren't an attorney and can't provide legal advice, but that you can direct them to some information about victims' rights on your website and offer to provide them with information to try and connect them with a lawyer if they would like advice about their specific situation. Pause the video and consider which option is the better response. Let's discuss each option. Number 1. This option is not okay because you're giving legal advice in the form of a legal opinion. By concluding that the court will require the victim to turn over the documents, as well as talking about legal consequences, that they will get into trouble if they don't comply, is legal advice. Number 2. This response starts out with providing legal information. However, it becomes legal advice when you tell the victim what they should do regarding the law in their specific case. Number 3. In this option, just because you tell the victim you cannot give legal advice, that doesn't free you up to then give it, so this is not the best response. Number 4. This is the better response. You provide the victim with information, which is okay, and then you offer a referral to an attorney. Responding to subpoenas may require a lawyer to analyze the process in which the subpoena was served, as well as the substantive argument presented. There are many ways to challenge a subpoena, including making an argument that the victim's rights require the court to quash the subpoena. Only when a subpoena is quashed by a court may a person legally refuse to turn over the documents. An attorney can also advise on how to comply with a subpoena in a manner that aligns with the victim's desired outcomes. So why does it matter, besides the fact that it is the law, that victim advocates do not give legal advice? Why is it important to make sure that victims speak with lawyers in particular when they need legal advice? Pause the video and take a moment to think of some reasons. And when doing so, think specifically about victims' rights. What might go wrong? Victim law is a new area of law. Many attorneys are unfamiliar with the practice of victim law. NCVLI is routinely contacted by other attorneys who are representing victims and don't know the law surrounding victims' rights, the remedies available to their clients, or how to go about doing what they need to do, such as how to represent the victim in court, how to file documents, or how to ask for what their client needs. So having someone who is trained to know all the ins and outs of the legal system, criminal law, and victims' rights is very important because victim law is still developing. There is also a system in place if an attorney provides bad advice, and that is malpractice. Unfortunately, there is some case law where courts in some jurisdictions have found that if an individual is harmed by bad legal advice from a non-attorney, there is no real recourse available. And bad advice can result in victims losing rights. The nature of victims' rights mean that they can sometimes be lost if not acted upon in a timely manner. If a victim acts on bad advice and the criminal proceedings end, there may not be any remedy available for that victim, or remedies may be limited. And finally, there is a risk of potential physical or emotional harm to victims that goes beyond the loss of rights if wrong or insufficient legal advice is given. And while acknowledging the reality that sometimes attorney referrals are hard to achieve, especially in specialized area of law like victims' rights, that doesn't take away the need for the attorney referral when someone needs legal advice. Let's do one more practice scenario. A client who lives in housing subject to Violence Against Women Act housing protection tells you that she needs a place to stay because her landlord finally got fed up with all the neighbors' complaints and evicted them. She says that her daughter has been in therapy for about 6 months and she has been paying out of pocket because they don't have insurance. She is financially wiped out and doesn't have any money for a deposit on a new place. You know that there are legal protections under VAWA and the Housing and Urban Development regulations prohibiting landlords from evicting domestic violence victims. Pause the video and consider whether you may tell the client about the VAWA and HUD protections. Yes, you may provide her with a plain language of the laws. In addition, if you know that there is an administrative program in your state that provides emergency housing funds, you can inform her of the program. You could also inform her of any victim compensation program that is in your state, as long as you do not suggest that she has a claim or a case under these laws or programs. It is good practice to have a disclaimer that providing this information does not mean that it applies to her case or that she will succeed in presenting a claim. This scenario is a good example of where unlawful practice of law could harm the victim. There is a lot going on in these facts, more than just housing issues. But even if the facts were limited to just presenting a housing question, housing issues are complicated. In addition, you don't know all the facts. The complaints that led to the eviction may be related to their dog barking and not related to the domestic violence. Referring to a housing lawyer or legal aid, where landlord-tenant legal issues are often handled, is the best way to ensure she does not pursue something that is not going to benefit her or her family. A lawyer will be able to discuss all the facts that would implicate legal protections in the eviction process. Remember, when complicated or multiple issues are presented, referral to an attorney is never the unauthorized practice of law, and you can provide a lot of information that may help the client without providing legal advice. And it's also, be careful about how you are saying what you are saying. Advocates often know of some really great resources, including non-legal resources, and we don't want you to feel like you can't give this information to a victim. Just be careful about how you phrase things. To reiterate, it's always okay to refer a victim to an attorney. Your organization may even have a policy about when victims should be referred to an attorney, like if they tell you that they have received a subpoena for their records. There are victims' rights attorneys who provide direct representation to victims in criminal cases. They can advise victims of their rights and provide legal and non-legal options related to those rights. It is good practice to know your community and what attorneys and organizations will provide this service to victims. NCDLI's National Alliance of Victims' Rights Attorneys and Advocates, NAVRA, is one such resource. NAVRA's Pro Bono Pairing Portal is a place where participating attorneys and firms can be paired with victims needing representation. A single organization is unlikely to be able to meet all of an individual survivor's needs, whether they are needs for information, legal services, advocacy, medical care, housing assistance, spiritual support, or anything else that can arise in the aftermath of a crime. Collaboration is key because it helps victims to get connected with the individuals who are best able and authorized to meet their needs, and lawyers are one part of that equation for survivors who need legal advice. Creating in-house policies and practices that help everyone in the organization avoid the unauthorized practice of law while fulfilling their role in the organization is key. Having forms and information about common issues victims face written up and available are excellent resources for both victims and advocates. Take a moment and think of some resources you might want to have on hand to provide to victims when asked certain legal questions. Bring this list to your supervisor or coworkers and see if something similar exists, and if not, create one. It is much easier to have a ready response to questions combined with useful information at hand so that you can serve victims even when you cannot give them legal advice. As stated earlier, identify when you might want to refer clients to an attorney who can provide them legal advice. This is a great discussion for your organization, and one that should be ongoing to ensure new employees are aware and to capture any new issues that have popped up in your office. It is also an option to reach out to the State Bar Association and ask if what you want to do is practicing law. The more your organization does to anticipate moments when legal questions may come up and how to address those questions, the more likely that you will feel confident providing services to victims without inadvertently violating the unlawful practice of law. If you would like to continue learning more about this topic and others related to victims' rights, additional resources are available both on NCVLI's website, ncvli.org, and on our website of our membership organization, the National Alliance of Victims' Rights Attorneys and Advocates, NAVRA, at navra.org. On NCVLI's website, you can explore a range of additional free resources, including a number of in-depth articles in NCVLI's Victim Law Library. You can also visit our website to request additional technical assistance and trainings on victims' rights-related topics.